Committee will reconvene. Let me remind the witness that he's still under oath. I yield 5 minutes at this time to Congressman Foster of Illinois.
Hi. Well, thank you, Chairman, and Mr. Paulson for your time here. Let's see, before I get into my main line of questioning, I was wondering if you could be of help in clearing up something that actually it's a public statement on the Minority Side website from this committee that having to do with the CPP program and its origins. And it says, it contains, among other things, the statement that yet under pressure from the House Democrats, such as Nancy Pelosi and Barney Frank, the Bush Secretary Paulson, Bush Treasury Secretary Paulson partially nationalized the U.S. banking sector despite his own misgivings about the inevitable perverse consequences to follow. And I was wondering if that is a reasonable characterization of the origins as you saw it.
No, it's categorically untrue. The facts are, we went to Congress to get the TARP legislation. Our primary thrust was the purchase of illiquid assets. That was really the source of the problem, and that was our strong intent. We got additional flexibility. After the legislation, it was clear that the problem was continuing to get worse. The facts were changing, banks were failing around the world, and there was quite a problem. We needed to move quickly to really put out the fire, and by far the best idea, and the only way we could think of doing it was with this program. It was not a nationalization of the banks. As a matter of fact, the program that we implemented when I was here had preferred stocks, purge stocks, which they don't vote. They're minority positions, and I have always said that this is something that would be abhorrent to me, nationalization. But we did some things, and a number of any kind of government intervention was not something I came to Washington to do, but it was better than the alternative. But we switched gears, and fortunately, Congress gave us the flexibility to do what we needed to do, which was to prevent the American people from really having a very serious problem.
Yes. Well, thank you for clearing that up. And I also voted, for the TARP authority, recognized at the time that this was a very important feature of it, that if things continued to get worse, that the only thing you could do fast was a rapid capital injection, and that this was an important element of it. And so thank you for clearing that up. Now, I'm interested in exploring the principle that you seem to be bringing forth in terms of that in times of systemic risk, that there are conditions under which the shareholders of a systemically important firm might be expected to take a bullet, so to speak, for the good of the overall financial system on the grounds that the firm, like everyone else, has much to lose if the financial system collapses. And that, moreover, that threats from regulators are appropriate means of encouraging them to take that bullet. And is this a reasonable, though a little bit perhaps stilted characterization of your position on this?
Yeah, that is not my characterization at all, because we were very fortunate in this situation to have an alignment of interests here, because I have no doubt what was in the best interest of the public, which was to not have Bank America collapse, not have Merrill Lynch collapse, not have the financial system. I happen to believe, and I think Ken Lewis testified he believes, that was also in alignment of interest with Bank America and Merrill Lynch. I believe that if Bank of America had invoked a MAC, tried to evoke a MAC, which was a legally binding contract, that was not legally valid. I think the merger contract
but still, you asked them to not pursue, they certainly had the legal right to try to invoke it.
Right.
And you had used what, basically, what could be, I guess, characterized as at least an indirect threat to encourage them not to attempt to exercise their legal rights. And I was wondering if you see that there's need for additional legal clarity in this area.
Well, I could say I think the more legal clarity we have, the better on everything. But on this, I just want to come back to the MAC, because I've heard people discuss this a lot. No one has ever dealt with, as far as I've heard, on the other side, the basic issue. Show me a Delaware court that after shareholders have voted has let a company get out of a merger by invoking a MAC. And this MAC actually had a carve-out for changing in market
Yeah,
conditions.
but your argument was that it was unlikely, not impossible, and certainly these were circumstances like Delaware courts have not seen in the recent past. And so are there specific issues of legal clarity? For example, some sort of safe harbor for CEOs that act in ways that might be construed under normal times as being against their shareholders' interest, but because this is a time of systemic risk and they've been given direct orders by the regulators trying to avert systemic risk? Do you see any merit in that kind of
That is something that I have. It's a very complicated issue, and it's one that I really don't feel qualified to have thought through all the arguments on this, but it is certainly one I think that bears consideration.
Okay. Well, thank you. I yield back.
Gentlemen.